This video is for educational and research purposes only and does not constitute legal advice. For any specific legal questions, please consult a qualified professional. Imagine an AI trading system executes a $1 million deal at 3 in the morning while its operator is sound asleep. No human clicked confirm. No one reviewed the terms. The algorithm found an opportunity and seized it. So here's the question. Is that a valid contract? And if so, whose contract is it? As AI systems become more sophisticated, a growing chorus in legal scholarship has begun to argue that contract law needs a fundamental overhaul. Some say these systems are too autonomous to be treated as mere tools. Others go further, arguing that AI deserves legal personhood. Eliza Mik disagrees strongly. No degree of technological sophistication warrants the emancipation of the computer, and all theories built around the ill-defined and decontextualized concept of autonomy must be discarded. Abstract in a provocatively titled 2020 paper, From Automation to Autonomy, Some Non-Existent Problems in Contract Law, Mik argues that existing contract law principles can handle automated contracting just fine. The problems, she claims, are not real. They stem from a fundamental misunderstanding of technical terminology. Let's break down her argument. First, some essential terminology. Mik draws a crucial distinction between two parties. The operator is the person who initiates the system, controls its functioning, and derives economic benefit from its operations. The person initiating the system, controlling its functioning and deriving economic benefit from its operations. The user, on the other hand, is the person on the other side, the one interacting with the system. Importantly, operators need not have programmed or designed the system themselves, but they are the ones who chose which system to deploy and set the transaction parameters. This distinction matters because operators directly benefit from the system's operation. And as Mik argues, those who benefit should also bear the risks. The first theory, the separation theory, argues that once a computer generates its own statements, rather than merely transmitting them, it becomes a separate legal entity. The transaction should be attributed to the computer, not the operator. Mik's response is twofold. First, legal personhood has never been premised on intelligence, consciousness, or autonomy. It's a legal construct, not a philosophical one. Second, and more practically, computers cannot pay damages or obey court orders. They lack the capacity for contractual liability. Computers are not contracting. We contract by means or with the assistance of computers. The second theory borrows from agency law. If a human agent can bind a principle, why not a software agent? Mik identifies a fundamental problem. Agency law requires the agent to be a legal person. The technical term agent, meaning any software that responds to environmental stimuli, has been conflated with the legal concept. The restatement third of agency expressly dismisses treating computer programs as agents and regards them as instruments of those who use them. She also exposes a logical trap in the general authority argument. If programming equals authority, then everything that derives from that programming, including bugs, emergent behavior, and unexpected outputs, falls within that authority. You cannot claim the computer acted within authority when it makes profitable trades, but exceeded authority when it produces losses. Proponents of agency theories cannot have their cake and eat it. And the apparent authority argument fares no better. Apparent authority relies on the perception of third parties. But can we really say that users regard websites or search engines as agents of Amazon or Google? Absent a perceived division into principal and agent, there can be no appearance of authority. The third theory tries to attribute cognitive states, intention, reasoning, decision-making, to computers. This is the intentional stance applied to machines. Mik's rebuttal is elegant. Contract law has never really cared about cognitive states. The subjective mental processes behind a decision are, in practice, irrelevant. Attempts to associate contractual intention with the cognitive states of computers ignore the fact that contract law generally disregards cognitive states. Having dismantled the theories against attribution, Mik presents three arguments in favor. These are prior intention, the objective theory of contract, and the computer as a tool approach. If the computer doesn't intend anything, where does contractual intention come from? Mik's first argument, the operator's prior intention embodied in the programming. When an operator programs and deploys a system, they are effectively intending all transactions that the programming enables. The computer doesn't make its own decisions. It executes earlier human decisions when preset conditions are met. The time gap between programming and execution creates a kind of remoteness of intention, but that is legally irrelevant. The rights and obligations are attributed to operators not because they specifically intended each future contract, but because they program their computers to send messages and execute commands, the legal effect of which is to create a contract. Think of it like a vending machine. The owner doesn't approve each individual sale. But by stocking the machine and plugging it in, the owner has made a standing offer to the world, what German scholarship calls an extended process of declaring intent. The same logic applies to algorithmic trading systems, just on a grander scale. This was confirmed judicially in the Singapore Court of Appeal's decision in Coin v. B2C2, which held that parties using computers to form contracts need not know the time of formation or the precise details of future transactions. Mik's second argument draws on the objective theory of contract, a foundational principle in common law. What matters is not the subjective mental state behind a statement, but what a reasonable recipient would understand from it. The question is not how a statement came into being, but whether the reasonable addressee would think the other party intends to contract on the terms provided. Under this framework, it doesn't matter whether a human or an algorithm generated the offer. If a reasonable person would understand it as a binding proposal, that's enough. The internal complexity of the algorithm is as irrelevant as the neural processes inside a human brain. In fact, research demonstrates that in most instances the mental origins of our own decisions cannot be understood either. The third and most powerful argument: regardless of their technological complexity, computers must be regarded as tools of their operators. This view is confirmed by case law. In the landmark Singapore case Coin v. B2C2, two sophisticated trading systems operated independently, without any human supervision. The court attributed the results to the operators, without hesitation. Yes, critics will say this approach equates hammers with tensor processing units. Mik acknowledges this, but argues it's a price worth paying. The computer as a tool approach equates hammers with tensor processing units. On a doctrinal level, this is a small price to pay for legal certainty, doctrinal integrity, and the avoidance of creating technology-specific regimes. Those who argue that autonomous computers cease to be mere tools have yet to provide any workable technical criteria for where to draw that line. And we must remember, even the most sophisticated computers have no goals of their own. As AI pioneer Norbert Wiener would say, we put the purpose into the machine. If everything is attributed to the operator, what happens when the system genuinely malfunctions? What if an AI produces transactions the operator never could have anticipated? Mik is skeptical of broad protections here. She makes an important observation. Operators will predictably challenge only unfavorable transactions while happily keeping the gains from equally unexpected profitable ones, a classic cherry-picking problem. Any protective mechanisms must therefore be approached with caution. And she argues that no novel mechanisms are required. Still, she identifies two existing pathways. The first is private contracts between operators and system providers. The liability for system failures can be allocated through the supply agreement, supplemented by insurance. The end user remains unaffected. The dispute stays between operator and supplier. The second pathway operates through existing legal doctrine, and here Mik presents two alternative routes. One is the doctrine of unilateral mistake. The contract exists, but may be voidable because the operator's system produced an erroneous statement. The other is lack of contractual intention, meaning no valid contract was formed in the first place because the statement never represented a genuine intention to contract. Crucially, Mik treats these two routes as interchangeable alternatives, not cumulative layers. Both routes converge on the same practical question: was the mistake apparent to a reasonable person? If the price is too good to be true, the reasonable recipient bears a minimal investigative burden. They cannot simply snap up an offer that obviously doesn't reflect the operator's true intention. The relevant case law here includes Hartog v. Collin and Shields from 1939 and Taylor v. Johnson from 1983. But here's the flip side. When the output looks commercially reasonable, the operator is bound, period. Deploying an autonomous system is a choice. Operators enjoy the commercial benefits and must be deemed to have assumed the accompanying risks. Holding operators accountable provides a strong motivation for minimizing the risk of their occurrence. These aren't just academic arguments. Mik's position is confirmed by multiple legislative instruments, including Australia's Electronic Transactions Act 1999 and the U.S. Uniform Electronic Transactions Act. Both proceed from two assumptions: a human has created or remains in control of the program, and the program is never regarded as a legal person. In line with the principle of technology neutrality, neither instrument introduces legal distinctions based on the degree of technological sophistication of the computer. Let's bring it all together. Mik's core conclusions are: first, all transactions produced by a computer must be attributed to its operator. Second, agency theories must be rejected. Computers are not legal entities, and users do not perceive them as separate from their operators. Third, computers are legally transparent. They don't produce legal effects. Their deployment simply doesn't prevent those effects from arising. Fourth, there is no need, at least in the context of contract law, to distinguish between individual technologies or to dissect how a system generated a transaction. Mik does leave one door open. She acknowledges that when artificial general intelligence becomes a reality, the discussion may need to be revisited. But, she notes with characteristic directness, at that point, scholarship will face far bigger problems than the correct application of contractual principles. Thank you for watching. If you found this helpful, please like, subscribe, and leave your thoughts in the comments.
See you in the next one.
Full citation, Eliza Mik, From Automation to Autonomy, Some Non-Existent Problems in Contract Law, 2020, SSRN Working Paper. Available at https://papers, ssrn.com/abstract =3635346.